Yes, good afternoon.
So, you submitted an application for leave to appeal.
That is correct.
It was filed in the time prescribed in the Criminal Procedure Act. And so today was set for the date that you now come and formally using notice. So that this court can consider whether it should grant you the application, go on to the High Court. I just want to confirm from you, you are still appearing in person.
Yes, I'm appearing as a private man. I don't use an attorney, no, that's correct.
Okay, so this is, I received a copy of your application on the 9th of March. So, just want to, I don't think it's necessary, this will form part of the record. There's no need to be dialed in back into the court record.
Okay.
Because it now becomes part of the record. I take it that you are appealing, you're applying for leave to appeal against both the conviction and sentence.
That's correct.
See, what normally happens with the notices of appeal, it clearly indicates on the one side appeal against conviction and grounds, appeal against sentence and grounds. Okay. So I take it that, for instance, your paragraph 1 is appealing against the sentence based on the fact that the one which was imposed by this court doesn't apply to the next court. Is that what it is?
Well, it basically says that the fine imposed was also not the limit stipulated in the Magistrates Court Act. That's based on the statutes of the Republic of South Africa. And the other reason to dismiss the matter or to appeal the charges is basically, like I've said, this is a matter of subject matter jurisdiction where you are a creature of statute and the whole apparatus is, and I'm a living man. And we have a conflict of jurisdictions here. And that's why I also always decree the court of record to represent myself as a living man, because we have enough conclusive evidence that there is some sort of miscommunication in between different jurisdictions going on.
So you just confirm everything you said in this application? That's what
yeah, I think, have you familiarized yourself? Yes, and have you familiarized yourself with the application? Or you've been through it? Okay. Okay, no, I'm just double checking.
For you to present it and just confirm with me, that's why I'm asking some questions.
No, this is what I've served, and this is what I'm presenting, and that's what I stand for.
So, is there anything that you want to highlight?
I think it's all in the papers. You know, I could repeat what I've written down, like we do in motion court, basically go through the application point by point. And I've clearly indicated why these corporate foreign jurisdiction statutes cannot apply to the living man. And I think that's becoming evident all around the world in various other court proceedings, that there's something at play here that you might not even be aware of, and that we would like to bring to the attention to the people that we have tried in the Constitutional Court, and the only thing that was left us to do was establish an international tribunal where we can hopefully address one of these issues, which is the fraudulent jurisdiction imposed on people in most of the world courts. And we also always like to invite you, you're not the enemies in the field, the corporate status or the banking cartel that owns the corporate government, and we have always been inviting people to come forward within the judiciary to actually get more information about this, which seems to happen in other parts of the world, and we are very delighted about the fact that prosecutors, for instance, in Lithuania have joined the cause to go, I want to say go up against the government, but go up against or expose the corporate government, which is a different entity. And this is, I think, also clearly in the old case law of cited here from the United States, where it says no corporate jurisdiction over the natural man. And I've clearly indicated, and I think I made clear by various trust declarations and recording myself with the Republic of Good Hope, that I am nothing but a living man, and I'm not a person. And whether that's the truth or not, and we're all sucking this out of our thumbs, it is up for an international, unbiased, objective tribunal to establish the facts, how this is being played out. And that's all we want to do. We just have a couple of questions, which we have to the Constitutional Court. Unfortunately, they're not willing to engage with us, and we have to take it a step further.
Anything else you'd like to?
No, and basically what I pointed out in point one, what seriously upset me, that's why the tone in my application maybe sound a bit abrasive, that someone of your statute and with experience, I think, should have also known about the maximum fine that could be imposed for an alleged offence in this regard.
Anything else?
And that's basically it.
We'll give you an answer to your grounds that you want. Statements and rights to make use of your just take a seat.
Great.
Yes, Your Worship, I would be wrong. Actually, the state is going to oppose the application to review, Your Worship. Firstly, we produce the documentation and thirdly, Your Worship, the access to the state documentation or the unfortunate that citizen of the country form of the violation will be picked up on the 18th. And it is clear to be of such a nature, Your Worship, that it should not be complied with, Your Worship. Such even make the land of the law lies in unfortunately that all acts of faith in that regard. Firstly, the second was also an important finding in terms for the lower court made a finding in terms of a ground method, which is so condition based on capability, which was such very difficult, and they first was taken in answer to a court of appeal. Why? Because the area of the cell is such ground for judgment when or they will not interfere with that court finding of an interpretation of the fact or the credibility of the evidence that was testified in that regard. So with that reason, we had to discuss we are doing the issue actually having it was started in 1991. That's the criminal report to worship, among others, we read it in worship in relation to the fine imposed to worship. If I read the documentation to understand the grounds for sure on the magistrate what they see was convicted of. They see was convicted of Supreme Court as therefore, I'm worried around we would be not be drawn to the report. I'm not aware of the obligation to observe international rules and norms. However, it is common sense that those rules and norms are not binding on the Republic. The state has ratified any type of international agreement which is not the case yet. So, although the court can observe the instances as stated in the appeal application, in no circumstance are the circumstances bound to the judgment and decision of the court, not within countries
anything else you want to say?
Yes, as far as I remember, the alleged statutory charge was a contravention of the Magistrates Court Act, if I remember correctly from the charge sheet. So it wasn't according to the Supreme Court Act, as the prosecutor has just indicated. In regards to the laws of the Republic and that they apply to everyone, so then it's up for the state. The state is claiming that that is the case, and as per the maxim in law, who claims proves. So it's up for the state to prove that I'm, as a living man, subject to these laws or statutes. And if the court has got the ability to make such a declaration here today, and if the court can make such a declaration, can the court provide the proof for such a claim? That in fact I'm subject to statutory law and not common law or natural law. And in fact that it is relevant to every man and woman in this country. And what I've stated also in my application, as per the Act 108 of 1996, it clearly states everyone has got the right to leave the Republic. What is the Republic? A geographic area, or is it a legal concept or legal idea? I have indicated and clearly demonstrated I've left the Republic, and so if the Republic still imposes its laws on me, there will be a violation of human rights, because I've left the Republic. Does that make sense? But you see, all these rights in the Constitution, they are basically just stipulating, they are check and balances for the government. How far, what they can impose and what they can do. And if the Constitution grants the right to leave the Republic, and it also interestingly says that everyone has got the right to leave the Republic, but every citizen has got the right to enter the Republic. So I've clearly left the Republic, I've entered another Republic, the Republic of Good Hope, and I'm subject to their laws. Now it's up for the state to make a declaration to prove me wrong that I can't do that. And that the state until has failed to do so.
Anything else you want to add?
There was one more point. No, I think that's basically it. Yep.
I said, well, I seek to you that I've had the opportunity to read your appeal from the worker and hear what you say softly. If I'm required to give reasons for what you have, either I say you have the right to appeal to the High Court, and if I refuse it, I have to give reasons. Let's understand that whatever reason that you are confined to your national appeal, can't go outside those areas. Okay, so the situation is that in terms of Section 309B, 3A of the Criminal Procedure Act, you are required to set forth clearly and specifically the grounds upon which you desire to appeal. Okay? Now, as stated in the case of the State v. Smith, 2012, Volume 1, South African Criminal Law Reports, page 567, the Supreme Court of Appeal case, the appellant must convince the court on proper grounds that he has prospects of success on appeal, and that those prospects are not remote, but have a realistic chance of succeeding. One of the aspects, some of the aspects of a notice of appeal must be such as to enable the court to ascertain the grounds of fact or of law on which the appeal is based, give the representative for the state a fair opportunity to prepare for and address paper grounds on which the appellant seeks to attack the judgment of the court, to enable the magistrate properly to react to such grounds and to furnish the court the benefits of its reasons. What I'm quoting now are aspects which are required to be taken, or should be taken into account by an appellant when it comes to his or her notice of appeal. And it's also to reiterate that the following objects are to be served by notice of appeal. Firstly, to enable the magistrate to frame his reasons for judgment. Second, to enable the respondent to abandon the whole or part of the judgment in his favour if he finds that he could not hope successfully to contest the appeal on the grounds, whether on law or fact. And court should be able to know what aspects are to decide on the appeal before to address the points that are raised. So, having said that, the theme of your application for leave to appeal is based on the following facts. First of all, the magistrate lends himself to racketeering schemes, extorts money and makes profit from what you cite as corporate RSA. Second point, you stated amongst the grounds of the state is yet another private corporate entity cannot be recognized by any living man. Third point you raised is that you have established a private divine trust as per the U.S. First Declaration, and you referred to the application. Fourthly, you indicated in your application that the Constitution is nothing but a piece of paper. Fifthly, you say that you have entered another republic. Sixthly, you say that there's no independent judiciary because the magistrate, the public prosecutor, and the witness work for the same company. And the other ground is that the magistrate has fabricated and consolidated a claim against the sovereign man without jurisdiction. Those are the parameters of your notice of appeal as they appear throughout from the first page to the last. Let me make it very clear to you, sir, that these aspects relating to accusations of racketeering and other aspects with regards to the integrity of the judiciary and its competence are in the opinion of this court's relations and misconceived aspersions on the competency of the judiciary as a whole and on basis and without foundation. We should be reminded that an injurious insinuation concerning the professional competence and integrity of the courts is a serious one. Grounds alluded to, those ones I have listed, are not grounds that have to be considered for this appeal at all. With regards to paragraph 1, you have stated that, or you referred to the Magistrates Court Act and its sentencing regime. To point out to you that you entirely misconstrued the section of which you were convicted. The Magistrates Court Act, sections 106 and 107, you referred to, has nothing whatsoever to do with this case. You were convicted according to section 40 of the High Court Act. And each penalty were referred to in this court's reason when it was getting sentenced. And it imposed the penalty which is prescribed for in terms of that act. It also follows, therefore, that having misconstrued the section for which the act for which you were convicted, that there is no ground with regard to count 1 that can be considered with regard to sentence. You've not canvassed any other aspects related to sentence. With regard to paragraph 9, it's the only other aspect that I can find in this application where you are saying that your evidence was ignored. The accused, your evidence was not ignored. Your evidence was evaluated along with that of the state witnesses, and it was rejected as reflected in the court judgment. The only issue that was to be decided in this matter is whether or not there was an obstruction on each of the occasions. In both instances, there was an obstruction which was confirmed even by you with regards to your own evidence, and this was alluded to in the court's judgment. No assault charge was dropped. The charge of assault was an alternative charge to count 1. In other words, the state chose to add an alternative charge because it felt that it didn't have sufficient evidence to convict you with regards to the main count 1. It may have resorted to pursuing the alternative count of the assault. So there is no such thing as that aspect of assault, which fits in anyway. And I said in my judgment that the assault aspect did not play any part in coming to the court's conclusion as it did with regard to what it determined constituted an obstruction with regard to count 1. The evidence of Mr. Lodge and Mr. Palmer do not take your case any further, as neither were present at the time of the 2 obstruction incidents. Mr. Palmer's evidence was of a character nature, calling to indicate to the court that you were not.
No objection. That was Justin Maxwell.
Was that Mr. Maxwell? The first witness?
That's correct.
Okay. Right. Thank you for drawing that to my attention. So Mr. Maxwell was called as character evidence. And he gave his evidence to explain how he knew you and that at no stage you could advise. But he was not present in any of it. The other gentleman that you called confirmed that you in fact stayed with his, at his premises on the 18th, from the 18th of December 2014. That evidence is neither here nor there because what was here is that you were on that property at the time of the incident related to count 2, from which the eviction order was tried to be effected by the sheriff of the court. And also, there was the unchallenged evidence that the property belonging to you had been pointed out by some other persons who were there on the day. And furthermore, came to light that in fact, the gentleman who's Mr. Lodge, who you stayed with on the 18th, indicated that he had left some property in your care at the garage of the premises, which were subject.
That was another gentleman. That was Mr. Palmer.
Mr. Palmer.
And I didn't stay with Mr. Palmer. I stayed with Mr. Lodge from the 15th and not the 18th.
All right. Continue. The contention that the sheriff invaded private property and executed a fraudulent court order is totally unacceptable. And as far as this court is concerned, just takes no. It cannot even be preferred to be considered at all. And it does not probably invite consideration any merit in the appeal. What the court, this court has decided is that therefore, when this court has evaluated the grounds of the appeal, is there any reasonable prospect set with regard to any aspect of that appeal that another court might fund? And in this regard, reference is made to what was said in Statement 2003, Volume 2, South African Penal Law Report, page 618. There must be a sound, rational basis for the conclusion that there are prospects of success on the appeal. So when the issues are narrowed down as far as this court is concerned, there's nothing on the question of state that the court finds to misconstrue the section